So at this point, we're very pleased that Professor Barry Hill from the Environmental Law Institute in Vermont Law School is able to join us today. Joe MacDougald is UConn professor and executive director of the Center for Energy and Environmental Law, and he's going to join the stage as well because Joe has been working very closely with Barry to plan this keynote. So Joe, I'm going to turn it over to you, and Barry, please join the stage, and I'll head off. Thanks so much.
Thank you, Katie. So welcome, everyone. I am Joe MacDougald. I'm a professor at the UConn Law School and the executive director for the Center for Energy and Environmental Law. I'm also an executive board member and director of applied research at CIRCA. So I'll be moderating this keynote session. As Katie had mentioned earlier, please use the question form to submit your questions for our speaker. We'll do our best to select the questions that represent the ones that are most on your mind. As Katie mentioned, SEAL is a proud co-sponsor of this event. So on behalf of myself, my colleague at the law school and the center's faculty directors, Professor Sarah Bronin and Luann Cooley, the newly minted legal fellow for CIRCA and SEAL, welcome. Since its beginning, CIRCA has been fostering resilience by encouraging research, helping municipalities through grants and advice, and researching and developing the legal framework that supports resilience in our state. Connecticut should be proud that it's building so many tools. Yet one of the key questions on the frontier of resilience transcends the technological, engineering, and yes, even legal tools that foster resilience. In short, what does true resilience mean? The decisions we make now will shape the future. So what are the values that will guide those decisions that affect our environment, our community, our people, and the generations? Issues of equity, diversity, and justice are no stranger to those who study environmental policy, but these issues take on a renewed urgency in times of climate change and times of resilience transformation, which is really what we're talking about here. With this challenge and in this context, we couldn't be more thrilled to have Professor Barry Hill as this morning's keynote speaker. I first met Barry at an EJ-focused panel in New Haven. The panel was held in the morning of day two of a multi-day event, yet even in that early morning hour, the audience couldn't help but come alive listening to Barry's real-world experience with and passion for environmental justice. It was a great event. His inspiring background includes government service, putting theory into practice as the Senior Counsel for Environmental Governance of the Office of International and Tribal Affairs at the EPA from 2007 to 2015, and the Director of EPA's Office of Environmental Justice from 1998 through 2007. He's practiced at environmental law firms. He's worked as an administrative judge. His career also includes education and theory through academic work as an adjunct professor at Vermont Law School and visiting scholar with the Environmental Law Institute. Finally, Mr. Hill is an author of a work well known to many law schools and the appropriately titled Environmental Justice Theory and Practice, currently in its 4th edition. No intro is long enough to cover his entire resume, so I think I'll call it at that. Barry, the floor is yours. Thank you and welcome to the conference.
Thank you, Joe. I appreciate that. Let me pull up everything at this point. Can everyone hear me? I assume you do. My purpose today is to look at the Rhode Island's complaint against big oil and gas companies. My goal is to look back in order to move forward, not to discuss the status quo, but to offer some transformational thoughts regarding this rapidly evolving jurisprudence of climate liability litigation and how resilience, environmental justice, and climate justice have been incorporated into that particular litigation. This presentation grew out of an article on this very topic that will be published in December's issue of the Environmental Law Institute's Environmental Law Reporter. What it is that I've read practically all of the complaints in this area, including Connecticut's complaint against ExxonMobil that was filed September 14th of this year. Connecticut is alleging that Exxon violated the Connecticut Unfair Practices Act, which is something that other states are doing. The one thing that I would like to you to think about as I go through this presentation is the word vision. You have to have vision as far as these particular cases are concerned. And that's the AGs, but it's also the vision of state regulators, state legislators in passing the legislation, NGOs and community-based organizations, academics, and finally, the general public. What I've done is that I've organized this presentation along 3 topics. The first topic is whether or not there's a fundamental and inalienable human right to a clean, safe, and healthy environment. Is there any such thing as everyone being entitled to clean land, clean air, and clean water? If there is such a right, where is it listed, and whether or not it can be enforced? That will also serve as the basis for the second topic, disproportionate impacts from climate change, and looking directly at the Rhode Island piece of the complaint. I could not say it any better. That's why we're going to examine the words of the AG. And finally, I want to talk a little bit about the modern expansion of public trust laws, because they are indeed important in this area. Topic 1, fundamental and inalienable human right to a clean, safe, and healthful environment. Is this right on par with the freedom of speech, or the freedom of religion, or the right to bear arms? But one thing that we have to ask and answer is whether or not this is an aspirational goal or a justiciable right, whether or not an individual or individuals can go to court, or whether or not the Attorney General's office can go to court on behalf of those individuals, on behalf of the citizens of a particular state. So what I did was that we looked at national constitutions and the David Suzuki Foundation. The foundation says 149 out of 193 countries that are member states of the UN include some explicit reference to environmental rights, or to the role of the central government as it relates to its environmental responsibilities. Now, 96 out of those 149 constitutions recognize that citizens have a substantive human right to live in a clean, safe, and healthful environment. And we've seen climate change litigation in Pakistan and Colombia and the Netherlands that said just that, there is a substantive right. But as far as the US is concerned, the Constitution is silent. There is no right to a clean, safe, and healthful environment in the US Constitution. Moreover, there is no penumbral rights that are derived from the Bill of Rights, as the Supreme Court examined with the right to contraceptives in Griswold v. Connecticut, 1965, or the right to same-sex marriages, the Obergefell case in 2015. Okay. The next thing that we have to look at is this whole notion of whether or not it's a right or a privilege. Professor MacDougald, when he turned 18, he did not automatically get a driver's license. He had to take an exam, and as well as a driving test to show that he could drive. As a result, he was given a privilege. He didn't have an absolute right to a driver's license. But we have been talking about voting rights, and I chose this specifically because of the environment that we're living in right now. As you see on your screen, this was a picture, a photo that was taken in August of 1963 the famous March on Washington, where the Reverend Martin Luther King gave his speech, I Have a Dream. You see on your screen, voting rights now. We demand voting rights now. On the right-hand side of your screen, we demand an end to police brutality now.
Barry, I apologize for interrupting you. I don't believe your slides are showing at the moment. So they're just, the tech team is bringing them up right now. So,
okay.
So if we could bring the tech team up, if you could find the March on Washington slide, or Barry, maybe you wanted to share your own, and then Barry, just say next slide when you'd like. I think you should be able to see it on the Zoom. There it is. Good. Sorry to interrupt.
Okay. I'm not going to talk about the beatings, the mob violence, the murder of Black voters, or anything like that. I'm not going to talk about the moral character tests that were used at one time. I'm not going to talk about the requirement that the individual must own property. I'm not going to talk about guessing the right number of black jelly beans in a jar. I'm talking about, quote unquote, voting rights. Now, I think it is important to think of voting rights as, in layman's terms, as only prohibiting certain kinds or certain forms of legal discrimination and establishing qualifications for suffrage. Because in 1870, in the 15th Amendment, they eliminated race, color, or previous condition of servitude as a requirement for being able to vote. In 1920, in the 19th Amendment, you won't be denied the opportunity to vote because of your sex. In the 24th Amendment in 1964, by reason of failure to pay any poll tax or other tax for federal elections. What happened is that these amendments eliminated certain forms of legal discrimination. So that brings me to voting, back to voting again. You have in Florida what they call is felon disenfranchisement. In 2018, there was a referendum in the state of Florida because approximately 900,000 ex-cons in Florida wanted to vote. There was an amendment to the state constitution, but there was going to be an election coming up, a presidential election. And so it was, since most of these ex-felons were probably Black or brown people, the assumption was that it was going to be people who would vote for Democrats. So the idea was passed to the legislature. It was a Republican law, obviously. And they said before they could vote, they will have to pay for their financial obligations. This appeared to be a poll tax, but that was eliminated a number of years ago. The Federal Appeals Court said that the Florida legislation was constitutional. The 11th Circuit, in a 6-4 decision, upheld the new law and said it should not be considered a poll tax. So I asked the question whether or not voting is a right or a privilege. Is the opportunity to have clean land, clean air, and clean water a privilege or a right? Let's look at the nexus between environmental justice and climate justice. Both are ethical and political issues rather than just purely environmental issues. This was captured in the statement that's made by the University of Colorado, Boulder. Climate change is fundamentally an issue of human rights and environmental justice that connects the local to the global. Because of rising temperatures, human lives, particularly in people of color, low income, and indigenous communities, are affected by compromised health, financial burdens, and social and cultural disruptions. those who are most affected and have the fewest resources to adapt to climate change are also the least responsible for the greenhouse gas emissions, both globally and within the United States. So if we're talking about climate justice, we also have to talk about climate injustice. This is a study that was done or released in January of this year in the journal Climate. And they concluded that the current deadly urban heat waves disproportionately affect minority neighborhoods because of the legacy beginning in the 1930s of racist housing policies. These urban areas, they will have a number of heat events. Earlier, we heard from John when he talked about the potential number of heat events in the state of Connecticut, how they're going to rise very significantly. And if you look at the policies of the government, you can see that there was a decision that was made to segregate the housing in the United States. As a result, we see these heat events in these communities and people are being adversely affected. So it was an excellent article, an excellent study, and I commend you to read it. They looked at 108 U.S. urban areas and found that this is a real problem, and these people are going to be adversely impacted by climate change, even though they didn't produce a lot of the greenhouse gases. When you think about climate injustice, let's talk about climate refugees. There is no single definition of climate, what is or is not a climate refugee. But there are three things that are generally accepted. Number one, it could be as a result of sea level rise, or it can be as a result of an extreme weather event, or finally because of drought or water scarcity. Let's look at sea level rise at Miami. And I just chose these three cities on the coast of Connecticut. Miami. According to the World Resources Institute 2014 fact sheet, Florida is the most vulnerable state to sea level rise, and metropolitan Miami has the largest amount of exposed assets and the fourth largest population vulnerable to sea level rise in the world. Miami-Dade County alone has more people living less than 4 feet above sea level than any state except Louisiana. Miami is now called the New Atlantis. On the left side of your screen is a Google map of downtown Miami. The blue is the sea. Look and examine how it encroaches into the entire city in so many respects. This happens consistently as the sea level is rising. On the right-hand side of your screen is a computer-generated image of southern Florida in the year 2100. As you can see, Miami and so many other cities along the coast are buried by sea level rise. So I asked this question: if Miami and Florida is going to look like this, what about the people who live in Florida at that time? Will they be considered climate refugees? Yes, based upon the definition that we gave, it's sea level that's causing this problem. Now, the other issue may be scarcity of water, because 90% of the people in Florida rely on groundwater for their water. If the groundwater is taken over by sea level, by the sea, that water cannot be used to drink. Where do those people go inlet further inland into Georgia or some other state, they are climate refugees, just like the Puerto Ricans in September 2017, when the island was hit with that vicious hurricane, Hurricane Maria. Tens of thousands of Puerto Ricans came to mainland US. They are climate refugees. This is just a picture of a typical sea level rise of a home in Miami. This is what happens. They are spending lots of money in order to try to find ways to address it. Pumps to pump out the water. I don't know if they will have a solution as a practical matter. Is there enough money to deal with this issue? I don't know. Let's look at Florida. Connecticut has 300 miles of coastline facing Long Island Sound. What's going to happen to the towns and villages along the coast of Connecticut? As I was preparing for this presentation, I looked at this article, this 2017 article, Connecticut's Rising Seas, Are Towns and Cities Ready? They examined all of the cities that John talked about and even more. And if it's a 20-inch rise, that's great. That's really great compared to a place like Miami. But what happens to those folks? Are they potential climate refugees? Environmental justice. In the US, nearly 100,000 deaths per year are attributed to fine particle pollution. People of color are 3 times more likely to face exposure to this deadly air pollution and 2 times as likely to live near landfills and industrial plants, which increase the risk of being exposed to air and water pollutants. These statistics reveal a repeated and disturbing pattern of environmental racism. Environmental racism refers to the institutional rules, policies, or decisions that result in the disproportionate impact of environmental hazards on marginalized communities. A perfect example is the 85-mile stretch from Baton Rouge to New Orleans. With more than 150 facilities, it's called Cancer Alley. The picture that you see in front of you is a community-based group, Rise St. James. They're walking along a potential 9.4 billion, 2,500 acre sunshine project to be built on Formosa Plastics petrochemical complex. These individuals, these women, have joined together to address this constant problem emanating from Cancer Alley. This article, Graves of Enslaved People Pose Hurdle for Louisiana Chemical Plant. It's an interesting article because it talks about the ancestors of many of these people and how they're dealing with this current situation. That's a national problem. Environmental injustice. This was an article that was in Energy and Environmental News, September 30th, and it says, inexcusable. Ex-EPA chiefs decry uneven pollution impacts. There were quotes from Bill Riley from the first Bush administration, Gina McCarthy from the Obama administration, and Carol Browner from the Clinton administration. Let me focus on Carol Browner's statement. She said, and I'm quoting, "From my personal perspective, it is simply inexcusable and it has to be fixed. We need to figure out how to tread our way through the existing laws, the existing structures to make things happen." Unfortunately, the existing structure has not worked for Black and brown communities across this country and low-income communities across this country. So that's why there's this notion of constitutional environmentalism. This is a triangle that I used the last 10 years of my tenure at EPA before I retired. My job was to go to various countries in the Middle East, Africa, South America, Central America, and talked about using legislation. So it was legislative environmentalism. For our discussion, we're going to use it to look at constitutional environmentalism. At the bottom of the triangle, you see state environmental justice laws, state environmental rights amendments. You move up to the next arrow, compliance and enforcement. That's the executive branch. You move up a little bit, it's the rule of law. That's where the judges go. That's the role that they play. And if all of these parts of government, the legislative, the executive, and the judiciary are functioning properly, that's what we call good environmental governance. If that's the case, there's a possibility that climate justice and environmental justice could be addressed. Let's look at these environmental rights amendments in this map. 16 states, those are in pink, have policy declarations in their constitutions. There are 6 states that have what we call environmental rights amendments. Now, 3 of those states, Montana, Pennsylvania, and Rhode Island, have these environmental rights in their Bill of Rights on par with the freedom of speech, freedom of religion, freedom of the press, and everything else. So 16 states, policy declarations, 6 states, environmental rights amendments, 3 states have this in their Bill of Rights. So there's this notion of, well, it's possible that it's enforceable, that you can sue. If that's the case, the first question is whether or not this environmental rights amendment is self-executing, whether or not an individual can go there to court. The next question, does the plaintiff have standing? And the final question, what is the scope of the right and the standard of review? What I did in the upcoming article was that I used New York as an example. New York has an impending ERA. In November of next year, it will be presented to the voters through a referendum. New York's impending provisions is simple. Each person shall have a right to clean air and water and a healthful environment. Again, each person shall have a right to clean air and water and a healthful environment. New York also has environmental justice legislation that was passed in January of this year. And it says that no group of people, including a racial, ethnic, or socioeconomic group of people, should be disproportionately exposed to pollution, and so on and so forth. New York also has climate change legislation, Climate Leadership and Community Protection Act. They've established a number of things in that climate change legislation that's consistent with the EJ legislation. Okay, we have the basis, environmental justice, climate justice. Let's move on to look at how Rhode Island AG's office put forth these issues in their complaint that was filed in 2018. Rhode Island has an ERA. Rhode Island has environmental justice legislation. Rhode Island also has climate change legislation. Rhode Island's climate liability litigation, it was filed, as I said, July of 2018. There was a notice of removal less than 2 weeks later. What happens is in every one of these cases, big oil and gas companies try to get the case removed to federal court. If it's removed to federal court, there's a possibility that it will vanish. What happened is that the First Circuit Court of Appeals on October 29th remanded the case back to state court for trial. It's much too early to know what's going to happen, but at least that we can see that it's moving in that direction. Let's look at what they said. Paragraph 213. The state has incurred and will continue to incur expenses in planning, preparing for, and treating the public health impacts associated with anthropogenic global warming. The bottom of that paragraph, vulnerable populations such as the elderly, the disabled, children, communities of color, and low income are more likely to suffer health effects from high temperatures. Remember what I said, heat events in urban areas? That's what the Rhode Island AG is saying. Increased prevalence of vector-borne diseases, increased pollution, and increased allergens caused by increased surface temperatures will further contribute to increased hospitalizations in the state. Paragraph 216. Instead of talking about climate refugees, they refer to as population displacement, vulnerable communities. And here they say the Rhode Island Emergency Management Agency has already incurred costs to improve resiliency to future disaster through planning and preparedness activities, trainings, and adaptation programs. Again, the state is using money in order to move forward as far as resiliency and adaptation is concerned, and it's because of the conduct of the defendants. Paragraph 218, the state has incurred in significant expenses educating and engaging the public. These efforts include by educating vulnerable populations about the public health impacts of extreme heat waves, such as heat stroke, drought, diminished water supply, and other climate-related impacts. Still further, paragraph 89, they talk about population displacement. 90 says extreme heat-induced public health impacts in the state will result in increased risk of heat-related illnesses, such as heat exhaustion and dehydration, increased hospitalizations, and death. Paragraph 93. Public health impacts of these climatological changes are likely to be disproportionately borne by communities made vulnerable by geographic, racial, or income disparities. They did a pretty good job as it relates to incorporating resiliency, environmental justice, and climate justice into their complaint. Topic 3, modern expansion of public trust law. I thought that this would be useful because of what's needed to help, what tools are needed to help AGs move forward with these cases. I have up there, groundwater is a public trust. Vermont, New Hampshire, Connecticut, Hawaii, New Jersey, New Mexico. The groundwater does not belong to any individual or any corporation. It belongs to the people. And it's the responsibility of the state to ensure that the groundwater is protected. However, air is not a public trust resource in Oregon. On October 23rd of this year, the Oregon Supreme Court said that since it's not in the law, we're not going to expand the public trust doctrine at all to include the atmosphere, as a public trust. So these are my observations. Additional tools are needed. What are the tools? Environmental justice laws that New York, Rhode Island has. Climate change legislation, it was incorporated tremendously in Rhode Island's lawsuit. It's not just a violation of consumer protection laws. ERAs, if there is a right to clean land, clean air, and clean water, it's going to be in an ERA, and it's going to be the responsibility of the state to protect those resources. And finally, public trust laws. Air must be a natural resource. As I said, the word vision is so important on the part of so many people. And I have this quote by Helen Keller. As you know, she was an advocate for the blind and the disabled many years ago. And in response to a question, is there anything worse than blindness? This is what Helen Keller said. The only thing worse than being blind is having sight, but no vision. The vision of the legislators, the AGs, the regulators, and others are so important in order to move this issue forward, to protect the environment and to protect, more importantly, the lives of people. Thank you.
Barry, thank you. I'm sorry that we have muted boxes because I'm sure you're being denied the sound of the applause that you really deserve. Thank you for sticking the landing on timing. I want to ask just one question that I think is probably most on people's minds. We're coming into a time of what we expect will be a new administration and a new approach. And I was wondering in a minute or so if you could tell us what you think are the top federal priorities that you think would advance some of the issues that you're talking about here.
Well, climate, that's the big issue. If that's not addressed, I don't know what's going to happen. Since 1992, there has been an environmental justice piece of legislation proposed. It's never gotten out of committee. As a matter of fact, John Lewis introduced the Environmental Justice Act in 1992, and Al Gore, when he was in the Senate, introduced that. Like, I think that it is incredibly important. The problem, however, with the federal government is that you have Supreme Court case law that basically says that the issue regarding climate change should be addressed by the executive branch and the legislative branch, and judges should be left out of it. That was a decision, an AES case versus Connecticut, as a matter of fact. And Justice Ginsburg wrote that decision. So I think that it is more important for the states to begin to do this work. I don't think that at this particular point, we should look to the federal government for amending the Constitution, the federal Constitution. That may take a long time, but that's why states, as laboratories of democracy, are much more important. And truth be told, I am working with a coalition in the state of Maryland to get environmental justice legislation as well as an ERA pass. Prior to me getting on the line, it was introduced yesterday. No, it's going to be introduced later today in the House of Delegates as well as the Senate. So there's a lot of activity, and I think that the states are where the action is going to be, and not the federal government necessarily.
I appreciate, unfortunately, this is all the time we have, but I want to thank you again so much for delivering what are really perfect remarks. And I think this is actually a terrific transition to what comes next. Thank you so much for making time for us.
Thank you.